What's up, everybody, and welcome in to potentially the last day of trial coverage for the Karen Reed trial. We're going to break down the closing arguments. I'm going to tell you what I would have changed, at least one thing in the defense's closing, and maybe more than one thing in the Commonwealth's closing that I think could have helped them tie their arguments together a little bit better. We're going to react. We're going to recap to some closing arguments that I thought potentially were made for the movies. Is that what they were trying to do? Is it not? Who knows? We'll talk about all that and more. I thought I'll hold my thoughts and my scores on the closing arguments till we actually get to it. Make sure you guys hit the like button. Make sure you guys subscribe to the channel. Let's get into it. So I think what we'll do is we'll break it down, we'll discuss it, and then we'll score it at the end. Okay. And I will also ask if your guys' vote changed, right? So we were at like 95, 96% not guilty yesterday after all the evidence ended. But now we're going to see if closing arguments by either side changed anyone's mind. And I was going to skip the intro and Jackson's, but I feel like it wouldn't do it justice. We'll put the intro in. I'm going to skip a couple parts here and there just because I don't have time to listen to the full hour of both. So there will be some skips where I'll summarize what they argue about and talk about. But I did think to give it credence and tie it all together, we needed to listen to the intro. So we're going to do that here. And what we expected, and somebody asked, what do I think the theme's going to be? What do I think they're going to do? And I said, I thought it's going to be the similar to opening and throughout the whole trial. Karen Reed was framed. She was innocent. She didn't do this. And to me, their strategy was more proving her innocence almost than arguing reasonable doubt. And if I had an overarching, I'm not going to call it an issue because I thought Jackson's closing was masterful to an audience of lay people. And they probably know this jury very well at this point. They know what's going to land. I know it's going to land with all of you watching this and listening to this. The way he tells the story, he feels resolute in it. Technically speaking, from a legal point of view and a lawyer looking at it, I thought this case, 99.9% chance you win on reasonable doubt alone. Still, obviously, 95, 96% chance you win on that she's innocent and here's what really happened. They chose the here's what really happened. I think they'll probably end up winning in the end. So I think it's going to come out victorious and look like $1 million. That's the only overarching thing I kind of thought is I feel like you almost, and again, I said it from the jump, it almost felt like they were creating a burden for themselves that we know the defense doesn't have, but they welcomed that burden. They had the goods. They presented the evidence, and that's what they want the jury to decide on. That's really what it felt like. So let's listen to even the beginning here of their closing.
Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs. Magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way.
So he's saying look the other way. He's saying that proves to her innocence. But if a jury's listening and they hear the jury instructions, all of those are major reasonable doubts too. And they want you to look the other way for every reasonable doubt. There are just way too many.
That's what they want. That's what they're counting on. But the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America. Lest the government stop answering to us and we start answering to the government. And woe betide any one of us who might find ourselves in the crosshairs of a Michael Proctor.
Protecting any one of us who may find ourselves in the crosshairs of a Michael Proctor. That was a hammer to start with. It's like one of us, you got to be careful. The golden rule. Don't put the jury in the shoes of the defendant. That came awful close. No objection, no corrective instruction. But he's like, imagine if you were someone Michael Proctor did something wrong. If he thought it, you know he's going to make it happen. And there's a lot more where that came from.
Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born.
So the lies building is also a similar theme we've seen in lots of trials. Once you start and you build that web, it's really hard to stop.
That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that.
So we knew that that's something they might have to worry about. And again, that's one of the major things I would have changed about Lally's closing is I would have pointed to that. Really. And I would have listed all 67 or whatever witnesses he called and said, all of them are really involved in the cover-up. And I know that's not what the defense is saying, but the defense decided to hit it head on. Like, I know you guys might find it hard to believe that people would show up in 2024 in this courtroom and just straight up lie to you, but that's what happened.
And try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over. They and others were caught deceiving you. Big things, small things. It didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn three pieces.
And people can say this is defense lawyers slinging stuff or twisting words or whatever. It's like, then how about you just produce the legitimate evidence? How about you're just honest? How about you're transparent? But when you're not, it gives this opening for this type of an argument.
Pieces of plastic into five right before your eyes. And even when they're caught with their own lies, they won't blink. They don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that could happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep them close. Offer them help. Offer them a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs.
I mean, that is just screaming reasonable doubt. And that's why I say when this case has a 99.9% chance of winning, it's because of all of those reasonable doubts, all of those things. A lot of people think they prove a cover-up, and that's fine. And maybe this jury thinks they prove a cover-up. But how can you just, like he said, look the other way and not even consider those reasonable doubts?
Create any logs whatsoever and don't maintain a chain of custody. Keep all the evidence in the hands of one person and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen right in front of you.
So, Hannah, this was the key comparison. Jackson told the story from beginning to end. Karen Reed didn't need to testify because Alan Jackson is going to tell her version of the events from beginning to end, what was happening behind the scenes, and then he's going to spell out to us exactly what happened in Karen Reed's, from her perspective or from the defense team's perspective, on January 28th and 29th. There will be no holes. There will be nobody wondering, I wonder what she would have said happened here or there. He is going to tell the story beginning to end. The way Lally set up his closing is, I'm going to tell you all the evidence again that you just heard. And as you know, if you've been watching my show or hearing me break down other closings, that is my least favorite type of closing, to just regurgitate all the facts and tell which witnesses testified to which facts. Closing is to connect the dots, bring your strongest argument, and hammer it home. And listen, I'm going to be honest, just for everybody now. You might want to stop listening if this is not what you want. I am going to be honest about how I feel about these two closings. And I have some thoughts. There's one major thing I would have done differently on the defense. There's a ton of things I would have done different on the Commonwealth's closing, even with what they had.
But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative?
Points the finger directly at the Commonwealth. Lally's table right there, they're in on it too. Whew.
Instead of the other way around. Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what
this guy obviously was a former prosecutor. This is such a prosecutor closing. It's like when you have all the evidence and you've prosecuted your case, you can claim the other side's just throwing everything against the wall and see what sticks. That's what most prosecutors accuse defense attorneys of doing. But when defense attorneys do it, it's legitimate if one of those reasonable doubts stick. Guess what? Doesn't work if just one of them could be reasonable that the prosecution throws up there. They have to prove it.
You saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Read. They desperately resorted to calling witnesses to talk about Karen Read and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Read and John O'Keefe that night?
And what's also interesting about the videos of C.F. McCarthy's and the Waterfall, obviously, just like the private text messages, John O'Keefe and Karen Read did not know those videos were going to one day be shown and used in court. And what did they display? You better believe if they were screaming at each other or pushing or anything, we would have seen it.
Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up into the time Karen Read dropped him off and he walked into 34th Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Canton family, it's easy to say, I didn't see something, because how can that really be challenged? Our second son actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house, and when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall, with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock you heard about in this trial. It was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data. Look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monotonic time, it aligns perfectly.
You see how he explains a fact, and then to make his point connecting the dot of that fact, he uses another fact in testimony and explain why that fact is actually more reliably pointing in his direction than their direction. That's how you're supposed to marry the facts and the arguments together. And it's seamless. It's telling the story from beginning to end. And I actually really liked, so John said, I actually wish we saw this Lally weeks ago. Lally did well. The public won't say so because Lally's the villain in this story, in my opinion, but not enough to win. So I don't think he did well overall. But what I will say is I thought he picked a great way to tell the story with the timeline. But then there were major issues with the timeline, which we're going to talk about. I love a good timeline. I love it. And you can put all the facts together and show how the dots all connect to tell the story, but I've got some issues with it. Lori Joe said, Peter, what do you think about the McCabe's and Alberts being present? I don't think, if I was the Commonwealth, I would have maybe said, don't. Like, just sit this one out. Watch it from home, because they look awful interested. I'm not saying this is any proof of anything, but if any of the jurors think they're in it, that's going to add fuel to their fire. Casey said, what do you think about the missing juror? So I don't know what to think. Some people told me it was a personal issue that the juror kind of asked to leave. Until we get more info on it, I don't really have a lot of comment on it. If you guys have more info, let me know.
They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she left. So,
I mean, honestly, you never want to take this risk as a lawyer, but it's almost like you could stand up, give your opening line, say that, and sit down. Because I don't understand how you make the rest work. Obviously, you would never do that. You have way too much evidence, way too much good stuff to go through. But that when everybody confirmed and agreed that 12:36 she connected to the Wi-Fi, that blew up the Commonwealth's timeline, especially when the opening statement said 12:45. But even the one they tried to finagle their way back into, it just never works the way they explain it. And then when you hear the accident reconstructionist explain how that doesn't work either, it's over. It's over.
don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie. And Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits.
I mean, the Apple Health data doesn't exactly place him inside the house. So those are some of the stretches we have to be careful of, taking fact versus he's saying that's the only place he could have been. I don't remember that from the testimony specifically.
And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 1229 to 1250. She was very specific about that time frame. But we know that the SUV was gone from 34th Avenue by about 1230. Had to be in order to connect to the Wi-Fi at 1236. So unequivocally.
So when McCabe said, I saw her, I saw the car move, I saw it, impossibility, because we know she's at John O'Keefe's house. So all that stuff that and that's, maybe this is my problem. Maybe John likes it because he looks at the evidence a little bit differently. The way I look at it, that stuff is not credible or reliable. So when Lally just comes up and spews it as fact, I'm like, we know that there are falsities in their testimony. So you got to give me something more than that.
Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that call me back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing?
And again, this is him connecting the dots, building inferences, reasonable inferences from the evidence. I think this is a good argument, but this is why when we get to the certain part of did they prove all this beyond a reasonable doubt, they didn't have to, so it's hard for my mind to get there. But he is telling the story in a way where he's connecting the dots of the evidence, telling the jury what he thinks it means, what he thinks it shows. And his story, here's what I'll say about his story. It is way too reasonable to look the other way on.
Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They've been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You could see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear.
And again, there's a lot of additions to this and commentary, I'll say, as somebody who's also providing commentary. Jackson is providing his commentary to what mannerisms we see on video and what's felt behind the text on the words on a text message.
So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I'll draw your attention to the waterfall tape if you're...
By the way, so here's a question you guys had in the chat yesterday. They're like, hey, did you see the part in the video where Brian Higgins did this or that and waved over to John O'Keefe to try to make sure he shows up at Fairview? And I was like, yeah, I saw it, but I don't really know if we should look into it too much. If the defense thinks it's important, they're going to bring it up. Guess what? You guys were right. Defense thought it was important. Puts it in his closing right here. You guys saw this and pointed it out to me.
If you want to take another look at it, it's at the 11:57 mark. Between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John. He motions for him. Come with me. And then at 12:20, he texts him, you coming here? This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps.
I will also say, and people will disagree with me, that is not the strongest evidence. The fact that they were, sparring or bear hugging, wrestling, whatever they're doing, that to me is hardly evidence that an hour and a half later, they're going to beat a guy up. I could be wrong and it could still have happened, but that's the type of stuff that when I really dig into it, I'm like, hard for me to get behind that, but lucky for the defense, they don't have to prove their case beyond a reasonable doubt.
Adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers. Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, your girl's been texting me. A push, a punch, a fall, pull Chloe off his arm, and now it's done. What is that? 5 seconds? 10? Doesn't take long at all.
So even his explanation right there, what happened? A punch, a push, a fall, pull Chloe off his arm. Even if it was an accident that went too far, it's not like he's saying he knows exactly what happened in that house. So I think that's important for us to recognize. They feel confident, and I tend to agree with them that they have proved the cops made this case happen with Karen Reed. Now, whether they covered up or knew what happened inside the house, they made sure this case was going to point at Karen Reed. I feel like the defense has proven that beyond a reasonable doubt, even though they didn't have to. And that, ladies and gentlemen, should be the end of it. But the whole time, the defense has felt like they have to provide a story to the jury. And even back to when Karen Reed was interviewed and she said, are we all in on the joke, Colin Albert and, whatever, Albert beat up John. My taillight's cracked. He's obliterated. So it fits in, and he felt the need to tell that story. And I think, when this thing becomes a movie, not if, but when this thing becomes a movie, this closing argument is going to be a big part of it. He gave them what they needed.
And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening.
So he even acts like it was an accident. Wasn't intended to go that far, but what's done is done. Then the cover-up starts.
At the Albert household, Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First, he said it was administrative work. Then he said he was moving cars. Then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up. And here's another.
It doesn't make any sense that he would go. Even his own excuse is something that doesn't make sense after drinking that much. And he does say he's drunk and he drives. He was not, holding back on saying all these people were drinking and driving. Now, what he didn't do was argue against the blood alcohol content, extrapolation, all that stuff that we were like, it really doesn't make sense. You got 1 hour. You got to pick your strongest arguments. He didn't feel like he needed to make that argument. I don't think he really said anything about it because he had much stronger arguments that prove the accident didn't happen the way the Commonwealth said.
Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted that I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they'd had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed. 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds.
I liked this as well. I liked this. I thought this was a good job. We've heard lawyers, stand in silence for 90 seconds or whatever to prove just how long that is. Well, listen to what he does.
That call is odd and suspicious enough, and just in itself, the fact that the call was made. But what's even more incriminating is that both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, the butt dials. Amazing.
I mean, that's interactive. You could probably say it with me. Butt dials. But sorry, this is when he says what can be said in 22 seconds. That's what I was saying I like.
But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call. Remember on cross-examination where I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds? Maybe? But the odd
definitely long enough for a quick conversation. Kevin said, should I be worried that a personal injury attorney knows the flight school I want to go to? No, it's a good flight school. It's a good flight school. I'll leave it at that. Reese's mom, is the judge going to include the consciousness of guilt instruction? I did not hear that. And what I heard so far, I have to listen to all of them though before. I'm planning on doing a video tomorrow as like a verdict watch. If the verdict happens today, we'll skip that one. Mary Claire, the day began with drama, removal of a juror and McAlbert sitting in the courtroom. My question relates to the jury four-person. Bev chose the four-person. I thought the jury chooses the four-person. It concerned me. So I heard Bev say earlier that it's common in the Commonwealth in Boston, in this courtroom in Canton, whatever, for the judge to pick the four-person. So I heard her say that earlier, so it doesn't really surprise me. Liz, do you think Jen McCabe, Brian, and Colin Albert helps the defense being there? Possibly. I don't think it helps the Commonwealth. Like, I don't know what's good about that for them. Does AJ and have KR take the stand if the defense feels they haven't proved reasonable doubt? What factors are in play when a defendant takes a stand? When there are major holes that they can answer that nobody else can answer or fix, and without them, you just feel like you can't win the case. That's the number one most important part. How long do you think the jury will deliberate for? And what do you think of the prosecution not mentioning anything about the actual crash? So I'll save my comments on the second part. Again, I think by the end of the day tomorrow, if I had to put a time on it, midday tomorrow. That's not a time. I don't know. 2:00 tomorrow. Azam, Peter, I thought closing goes Commonwealth defense, Commonwealth. Why did Jackson go first? Am I missing something? So I guess here, the prosecution has the burden, so they get to go first, meaning opening statements, and last, meaning the closing is last, instead of going first and last. So the defense just goes first, Commonwealth goes last. Very interesting. Some jurisdictions do that. Can the prosecution delay cases to hike costs for defendants? They're not supposed to, But what's the repercussion? Denise, question. If John was beaten up, why would they leave him right outside their home? Why, for example, would they not drive him somewhere else? Great question. And I thought that this was one of the really good points made in Lally's closing. So I'm going to wait and talk about it more when we get to his closing.
Behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. And that's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion,
he says kind of multiple times, it seems like they spent more of their case defending Jen McCabe than they did prosecuting Karen Reed, which is, again, something the public at large is thinking and feeling. I can almost guarantee there is somebody connected to this defense team that's tracking social media, all the data. What are people thinking? What are people saying? What's important? Why are people so entrenched in the not guilty or free Karen Reed? Why are people entrenched in the Karen Reed is guilty? Look at those two sides, compare the arguments, see what we need to handle. What's most important on this side? What's most important on this side?
Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was...
KG said, could Officer John O'Keefe's family sue for wrongful death in a civil court based on the evidence in this trial? I mean, they can, and it's a lower burden in a civil court. It would be a tough case, though. I do think based on the evidence that's out there. Doug said people are asking why he was left outside. He wasn't dead when they threw him outside, probably thinking he was going to call a ride home, but he was too hurt. So that would be contrary to the defense's expert who said he would have been knocked unconscious from that blow to the head.
Was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house. 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was nobody on that lawn, period, at 2:30 a.m. And what other suspicious thing happened that night?
So right there, I would have said, and guess what? That's something that's actually consistent with and again, by the way, just timeout here. This is me doing a timeout like Zach Morris. Me nitpicking as we're listening to this now. This is my second time listening to it, pausing while he's talking, being able to think. It's so hard to do a closing argument. He did an amazing job just from beginning to end, the smoothness of it, how it made sense, how it flowed, how it was captivating the whole time. It was a really good job overall. So I don't want these nitpicks to make it seem like I'm thinking, no, every lawyer's like, I could have said this, I could have said that. So put all that to the side. But it would have been really good if he would have said, and guess what? Laughlin's testimony that he didn't see a body is absolutely consistent with all 7 of the people that walked out of that house that also didn't see a body in the lawn. Now, they can tell you they weren't looking, but a 6'2", 220-pound guy is laying in the lawn. They walk right by it. And we're supposed to believe they didn't see it? No, he wasn't there. It's consistent through all of them, and it's consistent with Laughlin. Just a thought. Can lawyers object during closing arguments? Yes, they can. It's usually unbecoming. So usually they try not to unless it's really bad. Facts not in evidence, golden rule, things like that are the most normal.
By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered. Who's the only person in this case that you've heard about with Ford Edge? Brian Albert.
So see, some people were telling me Kevin Albert had a white Ford Edge and all this stuff, and none of that came in. And so I was very confused about that. So I guess the defense's point is Albert moved the car there to block so nobody would see them carrying the body out to the lawn. That's their theory.
Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabe's, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John, he walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back, he's not responding. Minutes start to pass, 1 minute turns to 2, 2 turns to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe you do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35.
He's literally testifying for Karen Reed here, right? Now, you would assume, most jurors are like, I assume he's talked to his client. I'm assuming his client told him what happened, right? Now, the Commonwealth could object and say facts, not evidence. She didn't testify, but he could say they put in all her voicemails. They put all these text messages. This is a reasonable inference that she is getting pissed. They even say she's pissed. So we're in agreement here. Why can't I argue she's pissed? And maybe the judge would have said you can't say specific words that she was saying.
Turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have. You and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk. He's been partying. He's hanging out. Just forgot about her.
So what's funny about that is he specifically does say the garage floor, which I didn't think about until I heard Lally's, and people have already mentioned it like, oh, she didn't take off her shoes in the house, then she must have done this. But he also says garage door, or floor, I should say, which I thought was interesting.
Her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking, what she was feeling. Now it's 5:23 a.m. She's woken up. She's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, the question was answered and her worst fears were realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her. You can feel the grief. You can feel the raw anguish. You can see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she reached out 53 times. She called him 53 times before finding his body. Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense.
Absolutely.
What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her
search, makes no sense, because even if you were trying to do it to set up a alibi or to show like, no, look, I cared, and I didn't do it. This is proof I didn't do it. You'd maybe call him once, maybe twice, maybe 3 times. You would not call 50 times. 50 times does nothing to provide some kind of alibi or concern. She clearly did not know what she had done. Or she did know she didn't hit him and didn't know where she was. It is proof that there is no intent. Proof there's no intent. If it was just that, I'm just talking about this one fact, just this one fact, it proves she either accidentally hit him or didn't hit him at all. They just are stacking all these good facts on top of each other, but just this one fact in isolation.
Looking for John. She backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this.
Now, I do think that his expert may have created some issues with that, but he doesn't have to mention it. It's his time to shine. It's closing argument, right?
It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible.
I mean, come on. They did not show us that the taillight was cracked, right? I mean, that is, if we're going to nitpick a little bit, They didn't show us unequivocally that the taillight was cracked when she backed into John's car.
Gasped in the courtroom when we finally showed you the actual video. You can see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important.
And it's a good series. He's right. It is that important, especially when we compare it to the one that Lally shows.
And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question...
And the reason he used that language is because that's what the unbiased cop said. I mean, that is lit up red. I have seen a lot of pictures, a lot of videos of taillight, people trying to show me stuff. This was, and we should not be surprised. This is their case. This is their job. They get paid the big bucks. They do a good job here. This is the best explanation and showing of there's no way the taillight was in the condition that it was in later when we see pictures that are in evidence. Again, just a great use. And you're only going to use one picture. You're only going to tell them to look up there one time. It better be important. And it was.
In your mind about the level of damage to that taillight at 5:07, all doubt was extinguished. When Dighton Police Officer Barrows walked into this courtroom, he's a sworn officer. He's not associated with Canton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look at this photograph and tell me, which one looks like Officer Barrows' description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so. You'll recall that after
Pretty good argument.
John's body was discovered, Lank, very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed. What with that whole thing about a dead body being on their lawn? That might get some attention. And they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too.
And again, it would be one thing to make these big jumps if we didn't have all the details in between that say that that's likely true. Kevin said, shot you an email about flight school. You can give some details. Yeah, we can talk on there. We can talk on. There's nothing. It's nothing big. Not a big deal. And there are a lot of good guys that go there and gals. Peter, in your opinion, how much has live streams cases helped reduce police corruptions since the 70s and 80s? I don't know. It's definitely going to highlight it. I think we'll see a better projection going forward. I'm not so sure looking backwards from now. It's made a big difference, but I think it's picking up steam now, and I think it will. I think this case is going to be important for that. Jane, do you think they'll charge her again if it's a hung jury? They shouldn't, but I almost feel like a hung jury would be a win for the Commonwealth at this point. But based on how they've tried to force fit her into this crime, I don't know. Can the prosecution file a judgment as a matter of law now that the defense has rested and no reasonable jury could find her guilty beyond a reasonable doubt? So they would not find a judgment matter of law because no jury would find her guilty. I think if they were going to file that, they would say no juror could find her not guilty, and they could make that argument. They would lose. If Karen Reed's found not guilty, can they still go look for blood in the basement of that house? Could they? Maybe. Is it likely they find anything usable this far later? Probably not. Charlie said, can we do a poll? Did she hit him or did she not? I mean, that is basically the manslaughter charge, because if she hit him accidentally even, you'd think guilty of manslaughter. If you say no, then she didn't hit him. If she hit him, she's guilty of something.
And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A wall that you can't scale.
No thin blue line, but a tall blue wall.
A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the toe time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important. I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized, so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16, and he finally had to tell the truth, or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Lochran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Lochran, he never disclosed his name in a single report. He hid it. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Outlets. If it were up to Proctor, you literally never would have heard of or from Brian Lochran. That's a scary prospect. I want to touch briefly on the additional physical evidence, or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there. And the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses. And all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that little hair, tiny, tiny little hair, barely perched on the side of that SUV, survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. A magic hair means nothing. The DNA means nothing. And that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside.
So they just throw the hair out. And again, they use common sense. How could it have stayed there this whole time? And that's how you can just kind of throw out a lot of the expert testimony that the Commonwealth brought forth to prove that.
Outside the taillight housing.
Now, if the jury doesn't believe that and they believe the expert testimony, then that argument doesn't hold a lot of water. It's all up to what the jury believes and thinks is true. Azam said, fact is not an evidence. How do you differentiate them? Facts not an evidence is not saying a fact is not evidence. It's a fact that never made it into evidence. So for him to say, we proved to you that the taillight cracked there, that fact nobody said. Could it have happened? Could it be consistent with this? Sure. So to say, or let's change it. Let's say he says, Karen Reed said she flew to New York City that night. It's like, whoa, objection, fact's not an evidence, because nobody testified to that. There's no fact of that. You can't make that argument, right? If you can infer it like she was in New York, so then you could say you infer that she flew there because she was able to get there in an hour, or whatever it may be. You can make an inference based on a fact that is already in evidence. Evidence is something that's record testimony or document or video or picture that's been entered into evidence. A fact is just something that we know to be true. So you can say something as if it's a fact, but if it's not an evidence, then the jury can't consider it. Now, arguments are arguments. So those are different. Those are you connecting dots, saying what you think it's pointed to, and you're allowed to do a lot of that.
Also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces. And no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that we saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, don't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight while he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it, which means that was done intentionally. That was not a mistake. And when caught in that obvious...
That's an argument. I don't know that anybody said that it would for sure have been inverted like that. And then when they inverted it, the timestamp was inverted. So I'm not sure. But the point is, he hammers home the point of they were being tricky with you. And Buchanan was in it, and Lally was in on it, and everybody was in on it. They said it was exactly the same. Clearly it was not. And they were asking specific questions in a way that makes you think they were tricking you.
Fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There's no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene.
I mean, that is huge. That is huge. All of this stuff to me, it's like, now I just feel like I'm like a broken record. Just, oh yes, that's true. That's true. That's correct. That's reasonable doubt. That's reasonable doubt. And guess what? That's why I've had some lawyers text me mixed reviews on this closing. Some like it, some don't. I say it's a home run for a layperson. And I think the chat's going to love it. I think the jury's going to love it. But at the same time, I find myself saying like, yeah, no way I could vote guilty because of that. No way I could vote guilty because of that. And when you feel yourself doing that enough, a defense lawyer is hitting home run after home run in their closing.
0. Stephen Seraph, Sean Good, Stephen Mulaney, Michael Lang, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene. Not a single piece. But incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. Now, here's some interesting testimony you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. He certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there unaccounted for. About 12 inches square. That's an area about as big as your dinner plate. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece.
So he explains where all the pieces were and how it doesn't make sense when the people were there searching. He also goes into, so people are all saying there's a verdict in. There's not a verdict in. When there is a verdict in, if there's a verdict in while we're streaming, we will go and just stream the verdict. Just FYI. Hit that like button if you guys haven't already. And Kelsey, why don't you go ahead and throw up the poll of, let's just say manslaughter at this point. Forget about second degree. Let's just say manslaughter. Say guilty, not guilty, or innocent. I just want to see how many people think she's not guilty and how many people think she's actually innocent. So go ahead and throw that up, and you guys can vote after you hit the like button. And we're going to skip the part where he talks about the medical experts and how they talk about they prove the opposite of what the Commonwealth wants you to believe, inconsistent with a motor vehicle accident, consistent with a fight, consistent with a fall, accident reconstruction guys not hired by either side. Either side could have called these guys. Quickly summarizes what they say. John O'Keefe was not hit by a car. Then he starts comparing them to Trooper Paul, which is an interesting part of the closing.
About the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34th Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house. That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. Because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, Paul, you'll remember his testimony.
Here it is.
I think I'm available to them. The Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony. I think I'm being kind when I say that Trooper Paul's analysis lacks credibility. Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm, even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement.
That is an accurate representation, maybe minus the pirouette, okay? Spin or turn instead of pirouette. That is an accurate representation of what Trooper Paul said happened in this collision. Wait till you hear what Lally says.
Before coming to his final resting place with his unbroken phone tucked neatly under his body. It's nonsensical. It borders on laughable. Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rinchler, both PhDs in engineering, both top of their field in accident reconstruction, both published peer-review articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense, and these men are unrivaled in accident reconstruction. What did Dr. Rinchler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, you can't deny the science and the physics. John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injury.
Pretty damning.
They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt?
By the way, all this stuff he's about to say they can't explain and they can't prove, guess where it's not? In Lally's closing.
And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to his back, to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing.
So he's making arguments, Netwoman, and in closing argument, you can make arguments, right? And this is where you say what you think the evidence points to. So yes, you can leave out words like alleged.
Pristine. Not a bump, not a bruise, a fracture on a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision.
The Commonwealth's best and brightest. I mean, throwing some major shade at Trooper Paul, and I got to be honest with you, he kind of deserves it based on his opinions.
Full collision with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise.
Makes no sense.
So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself.
And when he says stuff like he may have even, that's how you know they didn't prove this case beyond a reasonable doubt, but they didn't need to. They provided a reasonable alternative.
His hands were bruised and covering up.
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, festering malignancy that allows a that continue. And the answer should be not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat.
You knew we weren't going to end this closing without Michael Proctor. And somebody said, do you think, Jojo said, do you think AJ ran out of time and had to rush to the end? Maybe, but what I think he said is I think he had a last page or paragraph to make sure he hit, and it was Proctor. And then it was kind of the final thing he says in closing.
Talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an
But you repeated it about 5 times on cross.
Object, and went further by insulting her. He went further than insulting her and dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the
Who wants to be on the side of that guy? Not me. Probably not this jury.
homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth. Not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible related to human affairs. It's the
moral certainty is the highest degree of certainty. We're going to listen to him talk about this. It's about the only time he talks about reasonable doubt and moral certainty.
unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you. Not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that, which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies, the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth, and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
Okay, so the one thing I would have done when he was explaining for the last time that it was probably a punch and he was, defending himself and probably scratched his nose, I would have jumped to and read the jury instruction, knowing that the judge was going to read this later. So just listen to this jury instruction. Oh, I have to do math. 56. 56. 240 maybe.
Could refer to it in the jury room during your vote. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. What the lawyers or witnesses may say or suggest about the law is not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you on what the law is. So I now will turn to part one of the instructions, the general instructions that apply to all criminal cases. As I explained to you at the beginning of the trial, there is a fundamental rule that applies in all criminal cases, including this case. Every instance, you may not guess, you may not speculate, you may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over.
All right, here we go. So this is the part that I would have read at the end of closing. This is the thing I said, the one thing I would have changed in the defense's closing. I think he did such a good job explaining their story, how all the evidence, all the testimony lined up with their version of the facts, not the Commonwealth. It disproved the Commonwealth and proved the defenses. But guess what we actually put before you as a jury instruction? And here we go. It's going to be a minute or two till we get to the specific part. I'll pause it and highlight the specific part I would read.
Over logically, or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence.
Sorry, I think that was it.
Did not pile inference upon it.
I have not seen anything officially that there's a verdict. When there is, we will go over there. I promise. Okay, so here's the part I would read.
Inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition.
When the evidence stands equally for two different propositions, the Commonwealth has proved neither. So when he said all the evidence points towards what we said, none of it points towards the Commonwealth. But even if you felt like it was equally possible that our version and their version happened, they lose. Because that's not proving the case beyond a reasonable doubt. So if you're going to go with the way they said and you're going to prove your story and prove she's innocent, I hear you. I get it. It's dramatic. It's powerful. I think the people loved it. But just finish with that little bit of law. So even the jurors that are like, well, I don't know. I feel like he could have got hit in the arm. Well, guess what? If you just feel like he could have, and that's just as likely as he gotten in a fight, they lose and the defense wins. So I just thought that was a very interesting jury instruction to hear after listening to all that. Now we're going to get to Lally's closing. 221. All right. Oh, spinning here. Just FYI, no verdict, as you can see. All right, beginning of closing for Lally.
I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2022. You heard testimony from firefighter Timothy Nuttall. He was trying to bag-valve mask Mr. O'Keefe. He's working on resuscitative efforts to try to save Mr. O'Keefe's life. He asked if anyone saw anything or knew what happened. And the defendant said, I hit him, I hit him, I hit him, I hit him. Firefighter Anthony Flamati was asking if anyone had information on why Mr. O'Keefe was there in the snow. The defendant repeatedly said, I hit him, I hit him, oh my God, I hit him. Firefighter Katie McLaughlin was tasked by firefighter Flamati with asking for biographical information and for what the cause was of the traumatic injuries that all the firefighters testified that they observed on Mr. O'Keefe. She asked the defendant. The defendant said, I hit him, repeatedly. Firefighter McLaughlin asked for clarification. You did what? And the defendant repeated, I hit him. Senator McCabe stated initially over the phone when speaking with the defendant that the defendant said, could I have hit him in the car while they're on the phone with Ms. Roberts going from Mr. McCabe's house to Mr. O'Keefe's house?
As soon as you say, could I have hit him? You're admitting you have to now prove I hit him. You can't just take the fact that I said I hit him and that's it and it's over. That's not how it works. It's not how the law works.
Did I hit him? Could I hit him? Once on scene, once asked, as Mr. McCabe described by an EMT, for name, age, things like that related to Mr. O'Keefe, what caused the trauma? She indicated in her testimony that the defendant said repeatedly, I hit him. You heard testimony from Officer Saraf, statements that he attributed to the defendant as saying that morning, this is all my fault. This is all my fault. I did this. This is what the defendant is saying on scene. Since then, stories changed a little bit. But those were the words that came from the defendant's mouth on January 29, 2022, as John O'Keefe lay dying on the front lawn of 34 Fairview Road, where the defendant had left him after striking him with her motor vehicle several hours before, and then left him freezing there in a blizzard. There's certain things that have come up over the course of this trial as far as evidence and testimony concerned, little things. And what I would suggest to you, it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th and January 29th and beyond.
So he says, and his kind of theme is the little things. It's the little things that are going to pile up. And to me, it almost makes me think, so do you want us to forget about the big things? Peter, why do they call it the Commonwealth instead of state? It's just what they do there, I guess. Amy, is the jury aware the floor was replaced in the basement and the dog was gone the next morning and the house sold at a loss? So they're aware that the dog was gone and the house was sold. I don't remember hearing any testimony about the floor being replaced. And I don't think they heard that it was sold at a big loss. Why can't they reveal the FBI hired the reconstructionist? Because it's potentially prejudicial. And just because the FBI is investigating doesn't mean the Commonwealth did anything wrong or the cops did anything wrong at this point. It's just an investigation. So we couldn't hold that against a criminal defendant and we can't hold it against the cops or the Commonwealth in this case. Why are they able to charge MS? The Commonwealth says it was done on purpose. Manslaughter. Shouldn't they have to prove that? Manslaughter goes against that theory. So they are allowed to charge some differences. And John asked about lesser includeds. So I don't think they included lesser includeds in this case. I think both sides decided not to put that in the jury instructions. Why are innocent and guilty not the same thing? Well, they don't mean the same thing. Not guilty encompasses innocent, but it also encompasses not proven. So you can vote not guilty without believing she's innocent. And we had over, 6,000 votes, and it looks like 96% of people think that she's not guilty. And I'm combining the not guilty and innocent because 39% of that 96, so a little less than half of the people that would vote not guilty, think she's actually innocent. Only 4% have voted guilty at this point. And I'll just tell you, when our chat has been this lopsided, they've never been wrong. The only one we've been wrong about it was close to 50-50, 60-40. So usually that's pretty telling to what the verdict ends up being. We'll see. Melissa said, Peter, do you believe John was hit by a car? No. I think scientifically, physically, the experts, the defense experts at the end, I think proved to me it is very, very unlikely that he was hit by a car. He says the defense is going to try to distract you. You have to decide based on common sense. I was like, oof, not sure that's your best argument. He addresses the text with Proctor first, and I don't really know why. Right in the beginning, it's like it's not a good piece of evidence for you, so I don't know why you would say this is what I'm going to hit first, but that's what he does. He says they were distasteful, but guess what? They didn't affect the integrity of this case. And then he makes a great point. He says, those were personal texts. He never thought those were going to see the light of day, and you see nothing about a conspiracy or a cover-up in those texts. It's something we said from the jump. It's something a lot of you agreed with and pointed out. That's actually a good argument for the Commonwealth. There was this big secret cover-up, and he never thought that he was obviously thinking these vile texts that he was sending were never going to see the light of day. So if he was going to talk about a conspiracy or cover-up, he probably would have done it there, and he didn't. He explains a couple times what an amazing guy John O'Keefe was. And again, really getting justice for John O'Keefe is something the jury should focus on. And usually that's good for the Commonwealth. The defense is arguing, yeah, but they're not doing it the right way, basically. And he talks about and reads the text, how jealous and horrible Karen Reed was. And then he puts up a timeline. And I really like the timeline personally. And we're going to hear some of the discussion about the timeline, but there are also some major issues with the timeline.
MG stopped calling. This is during the time frame that Trooper Marino was talking. 2:38 p.m. Defendant texts John, I'm going to grab a drink in a bit. 2:38
I want to skip these. We don't need to hear him read. We don't need to hear him read all of those again. But I do like the timeline of the drinks.
Albert and Allison McCabe in reference to him getting picked up at that time. We also have testimony from Brian Albert, Cole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview.
Hold on.
This is during the
I
time frame.
skipped too far.
2:33 p.m. Defendant asking to go out for a drink. This is while Erin O'Keefe testified she was waiting for one of her children at the bus stop, picking that child up around 3 o'clock in the afternoon. This is also the point at which the defendant says to Ms. O'Keefe, "Wish I didn't speak to another O'Keefe after 2004. 7:30 p.m., you have Mr. O'Keefe and Mr. Camerano arriving at C.F. McCarthy's, with the defendant arriving at 8:51. 8:58 p.m. is when the defendant receives drink number 1 at C.F. McCarthy's. Vodka soda, tall cylinder glass, lime, and a strong. 9:13 p.m.
So again, just like I said when they played the video, pretty good evidence. All of these drinks. She has drink 1, 2, 3, 4, 5, 6, 7, 8, and 9. A really good use of a timeline. I love a good timeline. I use a timeline in every PowerPoint that I possibly can when I do closing argument, because visually I think it helps a jury see. And I was like, wow, the Commonwealth is actually going to do a timeline here. They're doing one of her drinks. Are they going to do one of the events of the entire day in 28th and 29th? I hope so, because I want to see how they're going to fit this together in the timeline. And they do, but there are a couple fatal flaws.
Number 2, 9:20 p.m. Drink number 3. 9:33 p.m. Drink number 4. 9:57 p.m. Drink number 5. 10:22 p.m. Drink number 6. 10:29 p.m. Drink number 7. 7 drinks from 8:58 p.m. through 10:29 p.m. when she receives that last drink at C.F. McCarthy's. Drink that she indicates to Sergeant Mechanic and several others on the next day that she did not take with her from C.F. McCarthy's to the waterfall. There's several individuals at the waterfall testify that she produced from her coat when she walked in, and that you can clearly see on the C.F. McCarthy's video her walking out the door with the same tall cylinder glass in her right hand. Now, keeping understanding that some of these drinks are not the full tall cylinder drinks. What she's doing is she's getting shot glasses of vodka and then pouring them into the drink after she's consumed the drink. 10:54 p.m. The defendant and Mr. O'Keefe arrive at the waterfall, during the course of which, an hour that they're there, the defendant receives drinks number 8 and drinks number 9. 12:10 a.m. From the waterfall video, you have Ms. McCabe, Ms. Polakithis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert, Cole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe.
Got to make sure he proves the McCabe's and the Alberts are innocent.
And then is driven home. 1 minute later, 12:11, Mr. O'Keefe is then on the waterfall video walking out with cocktail glass in his right hand. At 12:14 a.m., Mr. O'Keefe texts Ms. McCabe, "Where to?" 12:14 a.m., based on the fact that she's driving, and Mme. McCabe indicated in his testimony that she should call him instead of texting while driving, Ms. McCabe calls John O'Keefe, speaks with him regarding directions or going over which way to come in, Chapman Street.
The little things like they should, instead of texting and driving, you should just call, and you should definitely take your shoes off when you walk inside John O'Keefe's house. The little things that he mentions that they do right to try to add credibility to them is mind-boggling to me when he just told us that the horrible text to Proctor should not be held against him.
Over Cedar Crest as far as coming into Fairview Road. 12:38 a.m., the defendant's vehicle drives by the Canton Library. You can see that on the video. 12:56, the defendant drives by.
This is a good timeline because we have video to show all this stuff. So I like it. There's backing to this timeline.
Beth Abraham video. Again, you can see that on the video. Remember also the testimony from Lieutenant Tully in regard to the CSLI data and the ranging data in reference to coinciding with what you observed the black SUV from each of those respective videos. 12:19:32, Mr. O'Keefe enters 34 Fairview Road into his Waze app on his phone. 12:23 a.m. is when the defendant conducts a 3-point turn on Cedar Crest and travels back toward Fairview. That's from Mr. O'Keefe's GPS native location data from his phone. Around the same time, 12:23 and 12:24 is when you have that testimony from Ryan Nagel, Heather Maxson, and Ricky D'Antonio pulling into Fairview Road around the same time and pulling in behind the dark SUV. 12:25.
Okay, so now this is important. The wheel witness. Who's going to say Karen Reed was driving when all this was going to happen? Is he going to say Ryan Nagel identified Karen Reed as the driver of the SUV?
a.m. is the last native location GPS data of John O'Keefe's phone. It's in that area between 32 and 34 Fairview Road, where his body is discovered the next time, that finds the dark SUV. 12:25 a.m. is the last native location GPS data of John O'Keefe's phone. It's in that area between 32 and 34 Fairview Road, where his body.
12:25, which it cannot be based on other witness testimony. It cannot be the time of death as 12:25. It just can't be. And it doesn't match the key cycle stuff for Karen Reed either. So they are not saying it is 12:35, 12:25.
Body is discovered the next time, the next morning, in which there is no movement of that phone from that 12:25 a.m. period until Ms. Roberts then picks up the phone on the grass underneath Mr. O'Keefe's body sometime after 6 a.m. Have up on the screen right now is that data, those plotting points that Trooper Garino was testifying about as far as the movement of the vehicle. Movement of the vehicle as it comes down Cedar Crest, passes by Fairview, reverses direction, and then comes down Fairview, moving up, up as witnesses described, eventually stopping in that area of the property line between 32 and 34 Fairview Road, which happens to coincide with the vehicle control history database information from the Toyota text stream, which you now have up on the screen before you here, indicating that following that 3-point turn, approximately 8 minutes after that, from Trooper Paul's testimony, as far as the mileage, 36 to 38 miles, matching up with the time that the vehicle is in front of 34 Fairview Road, that the vehicle travels in reverse, in a straight line, with 24.2 miles per hour for 62.5 feet, with a minor steering angle change, which the trooper indicated was consistent with a pedestrian collision. At 12:30 a.m.
Is that minor change is consistent with a pedestrian collision. That's the best they got.
You have that second triggering event 8 minutes after the 3-point turn when the vehicle's in reverse at 24.2 miles an hour. 12:35.
I'm just going to pause this here. Okay. Tell me what's missing on this timeline. You guys are smart. Take a look at this timeline. Tell me what is missing. I'm going to look at the chat here for a second. Look at the time. This is from 12:30 a.m. to 1:02 a.m. What's missing on this timeline? Did they dust the glass for prints? That could have shown if someone in the house touched it and if it came from the house with further investigation. They talked about that. I think they said they didn't find any. There was like an unknown DNA was found on it. Peter, have you ever seen another case with this much reasonable doubt as this one? Yes, Alicia, I've seen other cases that are pretty bad as well. This I haven't seen as much proof that somebody's like actually innocent, but I've seen cases with a lot of reasonable doubt. Word is tow truck driver just made a statement that he did not drive the Lexus into the Sallyport. So who did then? At first he said, that Buchanan said that was me and that's Proctor. And then he's like, well, maybe no, it's not. Why put the body in your yard? No DNA in their vehicle. They can say they left it under his own power and got hit by a snowplow. Other vehicle. Karen Reed's behavior that morning presented a golden opportunity. I guess kind of lucky for them, right? People are saying verdict is in. It's not in. Just FYI, verdict is not in. Susan, Peter, please ask the chat if they voted not guilty versus innocent, what Karen Reed's culpability is. Okay. Peter, in your experience generally, do jurors questions and or requests during deliberations give you an insight as to which way they're leaning? Yes. Almost always, I feel like I am learning something from juror questions. Okay. So a lot of people put exactly what I was thinking. When did Karen Reed hit John O'Keefe? People are saying, when did he fly 30 feet? Not seeing time of death. When she supposedly hit him. The accident. When did he get hit? Do you know what the biggest part of my timeline is? A huge picture of the accident scene. The two cars melded together, the truck running over a car, whatever it is. That is the biggest focal point of the timeline. And everything else is smaller around it. Some text, some documents, treatment documents, pictures of a, cage on someone's neck, whatever it is. The focal point is the most important part of the case. They just don't have it. Again, I would never be on a jury. If I was, it would be over immediately. I almost don't care what else happened. If you can't put on there the actual time, and we have the second trigger 8 minutes after the 3-point turn, reverse at 24 miles an hour. So did it happen at 12:30? Because 12:30 doesn't line up with some of the other witness testimony, does it? So he doesn't put 12:30. 12:33, Karen calls John. At 12:36, she's at his house. So when did it happen? I assume now he's trying to say 12:30, but before he said 12:45 in opening. And if I would have remembered that again, that's a problem. The witness statements put her car out there until 12:45. That's a problem. None of it adds up. None of it's consistent. The fact that they didn't even try to lock themselves in once again is problematic to me. Why not just put he got hit at 12:30? I don't get it. That makes no sense and feels intentional. And he doesn't even say the time as he's arguing.
is when the defendant calls John, and that's unanswered. 12:36 is around the time that the defendant's phone connects to the Wi-Fi at One Meadows Avenue, Mr. O'Keefe's home. 12:37 is when the defendant leaves this voicemail.
And again, I really like the use of weaving in the voicemail into your timeline. I really like what he did. The pictures, the videos, the voicemails, the text message, weave them into your timeline. I think that's great. I think it's really effective.
37 is when the defendant leaves this voicemail. So within minutes of that vehicle's data, going 24.2 miles an hour in reverse for 62.5 feet, the defendant leaves that voicemail, seething in rage as she's screaming, "John, I fucking hate you." 12:40 to 12:42, Ms. McCabe is texting Mr. O'Keefe. She tries calling Mr. O'Keefe, gets no answer. You recall from her testimony around this time frame, about 12:40, she was unsure whether the vehicle was actually still out front or if it had gone at that point. But she was looking for John because she had seen the defendant's vehicle in front of the house and no one had come in. So she was wondering where her friend, Mr. O'Keefe, was. 12:55, the defendant texts John, "See you later." 12:59, the defendant calls, leaves another voicemail for Mr. O'Keefe. Exhibit 637, it sounded like this.
"John, I'm dealing with a fucking kid. Nobody knows where the fuck you are, fucking pervert."
But somebody didn't know where Mr. O'Keefe was. The defendant knew exactly where it was. She had driven him there, she had struck him there, she had left him to die there. 1:02 a.m., the defendant leaves another voicemail with no content. And then she texts John, "Your kids are fucking alone." 1:09 a.m., the defendant texts John, "I'm back in Mansfield. The kids are home alone." She's not. GPS, as far as it never disconnects from the Wi-Fi.
Like, what does that prove? She's not actually home. It proves she was trying to lie to John O'Keefe to get him to come home, right? I mean, that's the most, I don't get it.
Until the following morning. There's no indication that Ms. Reed left and went to her home in Mansfield at any point. 1:10 a.m., the defendant calls her parents. 1:11 a.m., she calls Mr. O'Keefe and leaves this voicemail.
"John, I'm going home. I cannot babysit Amy. I need to go home. You're fucking using me right now. You're fucking another girl. He's sleeping next to me. You're a fucking loser. Fuck yourself."
1:18 a.m., the defendant leaves another voicemail. Now, about 1:43 or 1:45 a.m. is when Julie Nagel testified that they were leaving the house. And she sees a large black object on the lawn near the flagpole while leaving 34 Fairview Road. Doesn't think much of it at the time, isn't expecting Mr. O'Keefe or any body to be out on the front lawn. 4:42 a.m., the defendant calls and speaks. The calls to her parents are finally answered. 4:49 a.m., the defendant calls Ms. Camerano, screaming, "Where's Mike?" 4:50.
So what else is not on this timeline? When the McCabes leave, when Higgins leaves, when the Alberts leave, when everybody leaves this house and walks right by the lawn and doesn't see a body. We have Julie Nagel seeing the black blob, which they need. They got to have that, because without that, you got nothing. But all the other people that walked by and didn't see him.
3 in the morning is when the defendant instructs Kaylee, Mr. O'Keefe's niece, to call Ms. McCabe. Why? Because the defendant doesn't have Ms. McCabe's phone number. Indicates that John didn't come home. We got in a fight, and I left him at the waterfall. Those are the first statements or the first version of events that she's able to communicate out to the world as to what happened to Mr. O'Keefe, where he is. We got into a fight. I left him at the waterfall. 5 a.m., the defendant calls Kerry Roberts, saying, "John's dead, Kerry, hangs up the phone. 5:01, the defendant calls Kerry Roberts again. And it's at this point that she indicates that John's dead, he must have been hit by a plow. 5:07 a.m., the defendant leaves One Meadows Ave. You have the video of that. It's number 153 in Exhibit 6. We'll get to that a little more in a moment. About 5:10 a.m., the defendant calls Kerry Roberts. Ms. Roberts starts calling hospitals, calling KPD, calling 9.
So they inferred multiple times that she went back around 5 o'clock, and they try to connect that later for her saying, I think it was to Sullivan, "John's dead. We found him at 5 o'clock," when it was actually 6 o'clock. So the best stuff they have, which again, we thought this in opening statement and it turned out to pretty much be true. The best stuff the Commonwealth had in this case is Karen Reed's own statements. Without that, what would they have had? Just imagine that. Without her opening her mouth, what would they have had in this case? We're going to skip the dash cam video of the snow and the darkness again that we've seen so many times. He finishes the timeline with, Jen McCabe makes the Google search at, 6:20, whatever, not 2:20. He tells us what the kids say one time at the beginning, and he basically just says they fought behind closed doors. So many people on Twitter were saying, "Oh, that was the best evidence. You guys didn't see it, so nobody's going to know what happened because the kid's testimony was the best evidence and proves she's guilty." Well, if that's all they said, that's definitely not enough, and we already kind of knew that based on the texts and the voicemails, but there's more on the kids later we are going to listen to. He talks about the defendant's movements that day and, going to her dad's house and where she went when she was in the O'Keefe's house and how she treated the O'Keefe's as kind of consciousness of guilt. I don't remember exactly if he said consciousness of guilt. He talks about Aruba. And then we get to more of what the kid said, which I think is kind of the important part.
Testimony from Ms. O'Keefe in regard to them exchanging, her and the defendant exchanging text messages on the flight down, arranging times to meet up. The relationship that John O'Keefe had when going into a room. Both of the children and Mr. O'Keefe kissed someone in the lobby.
This is Aruba.
Ms. Sullivan indicates that Mr. O'Keefe's phone is essentially blowing up, lighting up with calls and texts from the defendant. I would submit similar to the afternoon of January 28th. Mr. O'Keefe says she's crazy. And
Problem is, she didn't do anything to physically hurt John O'Keefe that night, right? So why are you comparing it to January 28th? It doesn't really help you.
Those doors in the house.
Here we go.
You heard testimony from the children about the arguments in the weeks and the months. I know this is a displeasure to the defense counsel that the children came in and actually testified as to what happened behind closed doors in the house. They both recall frequent fights. They both recall Mr. O'Keefe trying multiple times to break up with the defendant, asking her to leave the house, the defendant refusing to leave the house. His niece Kaylee, John tried to diffuse, tried to walk away, and the defendant would follow each time during each argument. They both indicated that Mr. O'Keefe had told the defendant that the relationship had run its course, similar to language within the text messages you have between the defendant and Mr. O'Keefe. That Mr. O'Keefe was sick of arguing, again, mirroring those text messages from January 28th, leading up into going out to see if McCarthy is eventually the waterfall, and the defendant killing Mr. O'Keefe in the early morning hours of January 29th. We have testimony in regard to the ring camera. Kaylee indicated in her testimony that John had that for about a year. So during the course of 2 years or so of the relationship with the defendant, he got it while he was dating the defendant. The defendant had the security code for the garage. Neither of the kids had access to the camera. Trooper Garino checked the laptop and the desktop that were left after the defendant did the quick cleanup upstairs with her father, upstairs in the home. Neither of those devices had access to the ring cameras. John had access on his phone. The defendant indicates, if you recall, in some of those text messages in regard to the romantic kiss that she placed on Mr. Higgins.
There was literally no evidence. In fact, the prosecution evidence said, in testimony said, she did not have access. There's no evidence that she deleted any of the Ring doorbell cameras or videos, yet he is still going to try to infer that she did, which is just crazy to me.
Higgins, earlier on January, whatever it was, during the Patriots, Mr. Higgins and Mr. Jackson was indicating weren't very good friends with Mr. O'Keefe, but had been invited over to his home for a Patriots game, at which time the defendant escorted Mr. Higgins out of the garage and placed a romantic kiss on him. But during those text messages, when they're talking about that, if you recall, the defendant is saying something or joking about something that Mr. O'Keefe had been looking at the videos and had been asking her if there was something going on with her and Mr. Higgins. And what was her response to that? I know where the cameras are. There are only 2 videos missing from that ring system. One being the defendant getting to Mr. O'Keefe's house after murdering him, and the other when the defendant is showing Ms. McCabe and Ms. Roberts the broken taillight, both of which, both Ms. McCabe and Ms. Roberts testified as having occurred. No video.
Again, that's the problem when the witness testimony is tainted a little bit, right? Usually you can really hold on to witness testimony if the witnesses are credible, but I mean, at the very least, Jen McCabe was dead wrong about what time she said she saw Karen Reed's SUV outside the house. You notice none of that comes in at closing. He's not talking about what anybody said they saw outside that window in front of the lawn at the time they said it. That wasn't on his timeline. If it would have fit, you better believe it would have been on his timeline. But none of it actually makes sense, which then turns the timeline against you if the jury's, paying attention. Mary said, I may not be recalling this exactly, chemo brain, but weren't we in Allure live when the Murdaugh verdict came in the same day it went to the jury? I don't remember if it was Murdaugh. There was a case we did that on, though. I can't remember either, if I'm being honest. Lulu said, Peter, many of us accuse Tally hit wrong button. Can we redo the poll? Pretty, please. Sure. We'll go ahead and do a poll for second degree because we did one for manslaughter. Go ahead and do second degree, guilty, not guilty, and innocent, just because it's interesting. 20K watching, 113 likes. That can't be right. Hit the like button. We're going to do the poll again. Hit the like button. 113 can't be right. But even if it's not right, we got 27,000 total, including, all other platforms. Hit the like button if you guys have not already. Hanny. Hey, Laura, if the jury, against all logic, finds Karen Reed guilty of all charges, can Judge Bev overturn the verdict? No. Well, not right now. There can be motions filed post-trial that she may be able to have an effect on, but not like right here as we see her. She can't just be like, nope, too bad, I'm going to say not guilty. She had her opportunity to do that with a directed verdict or judgment of acquittal, but she didn't.
The defendant tells in the morning of January 29th. There were text messages and voicemails from the defendant to Mr. O'Keefe, 53 phone calls from 12:33 a.m. to 6:03 a.m. 0 phone calls to 911. Defendant,
He says that as if that's a good point for his case. But from my perspective, if she really thought she might have accidentally hit him, she probably would have called 911, right? I mean, I guess if you think he's missing, you should have probably called 911 too, and she didn't. So I don't know why. Why did she not call 911? What do you guys think? Because she was like drunk driving, or because she just was still drunk? I don't know. It's a good question. He says unequivocally those searches were at 6:20 something, not 2:20 something. Again, multiple times defending Jen McCabe. He talks about how driving up and down the hill is the same thing as the data going up and down.
well, that's why she answers the phone at 4:53 in the morning. She then hears the defendant screaming loudly over and over again, Jen. John didn't come home, got in a fight, left him at the waterfall. The variations, different iterations of that story as it evolves and changes over the course of that morning. Ms. McCabe then indicates to the defendant, we saw you outside of my sister's house. Then she starts yelling, Jen, did I hit him? Could I hit him? Then they start discussing where the defendant brings up her cracked tail. And then both Ms. McCabe and Mr. McCabe hear the defendant screaming outside of their home at about 5 o'clock in the morning, shortly after 5 o'clock. They go to Mr. O'Keefe's house. And both Ms. McCabe and Ms. Roberts indicates, and you heard this testimony from a number of different witnesses, friends and family of Mr. O'Keefe, that he had a rule, pretty strict rule in his house as far as you take your shoes off when you come in the house. So what did Ms. McCabe and Ms. Roberts both
Here it is. Here's the damning evidence about leaving her shoes on.
when they're entering in that house on January 29th? They take off their boots, they get out in the snow, they take off their boots in the mudroom, and then they walk in. What did they both indicate that the defendant did that morning when she came back to the house? Walk right in with the shoes. You hear that second voicemail. It's after the defendant's arrived back at One Meadows Ave, after her phone is reconnected with Mr. O'Keefe's Wi-Fi. And you can hear
And that's when Jackson said she's walking in the garage.
footsteps. Or that may be in the garage, or that might be in the house. Why is it that the defendant has no issue with wearing shoes in the house when Mr. O'Keefe has that strict rule? Because she knows where he is. She knows it's not an issue. He's not coming home because she hit him with her SUV, that she left him in the snow.
Again, this is argument. This is when you can connect the dots. So at least he's doing some of it. She knew he wasn't coming home. Then he talks about how Roberts confirmed how John O'Keefe's phone was found under him in the grass, which proved what time he fell. It wouldn't have been snowing. You know, some of you guys talked about how the body heat could melt the snow and the ice and whatever. There was no evidence of that scientifically. So Lally's like making these arguments. I don't know why he didn't just call somebody to say that, right? So I think that's interesting. And he says the magic hair, as Jackson likes to call it, was frozen. And when it melted off, then you could see it. But then we had this. Hold on. This was the, one major picture that Lally put on the screen during his closing. We had a side-by-side by the defense, and now we have a side-by-side by the prosecution. And two things stick out to me. Number one, where is this car? It's at the Sallyport, very clearly. So the defense's theory is still that this all happened at the Sallyport. So how does it really disprove what the defense is saying? I'm not sure it does. Now, number two, I think it at least provides some discussion about if the light would still light up red with this much red. I think it would at the very least not be even between the two like it certainly looked in the defense pictures, but at least create some potential discussion between the jurors if there are jurors on the Commonwealth side when they get back and start deliberating. Then I want to play this part, but I may have already missed it when he talks about if Albert was such a criminal mastermind, why would he leave the body in the lawn? And it's a question a lot of people had in the chat. So I think it's good that Lally hit it.
You heard all that medical testimony in relation to, and you heard all that testimony in relation to snow and the weather and the wind. Wind gusts up to 37 miles per hour while Mr. O'Keefe is out there in just a shirt and jeans. Now, you heard also testimony from Ms. Roberts in relation to the injuries she observed from Mr. O'Keefe. That's initially on scene. There was one eye that was swollen, not the other. So that's indication of the swelling that Dr. Scorty Bella was testifying to, and no indication of physical altercation. And then both eyes being swollen when Ms. Roberts viewed Mr. O'Keefe's body after his passing.
So once again, and I didn't even mean to play this part, but he's explaining the injuries. But what he clearly doesn't do is explain how the car caused those injuries, which I find problematic.
Submit that all the testimony tells you the same consistent account, internally, externally, from civilian testimony to investigator testimony, medical testimony, to forensic testimony, to the reconstruction testimony. You have the testimony from Ms. McCabe and Ms. Roberts that they couldn't see Mr. O'Keefe at Fairview when they initially pulled up. You can see that from Officer Sarah's cruiser. You have Mr. O'Keefe being covered in snow from the storm. You know where Mr. O'Keefe's body was. It's clearly visible on the cruiser camera from Officer Sarah. You have testimony from each of the responding officers, anywhere from 5 to 12 feet off the roadway, and from the civilians as well. Ms. McCabe, Ms. Roberts, Officer Mullaney has 6 inches of snow on Mr. O'Keefe when he first sees him. Firefighter Kelly says that he couldn't even see Mr. O'Keefe until he was 5 feet away in the darkness, in the snow, in the blizzard conditions. There's no footprints around the body. There's no drag marks around the body. There's no evidence of anything in relation to Brian Albert and Brian Higgins.
Here we go. Here we go. Here's where he says, if he was such a criminal mastermind, why would he have done it like this?
There's no evidence of anything in relation to Brian Albert and Brian Higgins. Brian Albert and Brian Higgins spent January 28, 2022, traveling to New York City to go to a funeral for another police officer, for another department, who they didn't even know. Traveled all the way down to New York and then came back before the blizzard, only to come back from that, to go out drinking, to come back to Mr. Albert's house, to then murder another police officer who they did know, who worked for the same department as them. And then criminal mastermind genius that Brian Albert is, 28 years on the Boston Police Department, he's then going to just leave Mr. O'Keefe's body on his front lawn. Really? That's a conspiracy? What evidence do you have of that?
And then everybody else is going to have to get his back and stick their necks out to go to prison. I don't want to go to prison. I would say that, by the way, if I was Lally, I'd be like, I'm going to go to prison for the Alberts. I don't even know them, because Alan Jackson opened the door by saying the Commonwealth's in on it too, basically. So I would have thrown that in there if I was him, but he didn't.
You have statements that the defendant made to Sergeant Buchanan on January 29th. She was willing to speak, but didn't want to give too much detail. Conversational tone throughout. She indicated that the night before, they had gotten into an argument, something about what was fed to the children, nothing about the detailed arguments, incessant phone calls, and everything else that you saw from the defendant and Mr. O'Keefe's phone on the 28th. She indicated that she got to see F. McCarthy's around 9 p.m., started drinking vodka sodas, the men were drinking beers. When asked where she parked her vehicle, she said she parked on Washington Street across from C.F. McCarthy's, facing northbound on the side, same side as Waterfall. Same testimony that you heard from Ms. O'Keefe, observing the defendant going over to her vehicle, getting in the driver's seat, and the victim, Mr. O'Keefe, getting into the passenger seat. She said they were left the Waterfall, were invited to her residence. She drove her and John to the location in Canton. She dropped Mr. O'Keefe off, did not see him walk into the home. She, being the defendant, stated she made a 3-point turn and then left. When asked about the damage to her vehicle, she indicated to the troopers, I don't know, it happened last night. June 2022, you have that other reporting of that other version that she now has evolved into, as far as stating to Sergeant Buchanan, are you aware that John was beaten up by Brian and Colin Albert? We're all in on the same joke, right? John was pulverized and my taillight was cracked. What evidence do you have of that? Mr. O'Keefe never went in the house.
What evidence do you have of that? The injuries to John O'Keefe. That's the evidence we have that he was pulverized.
Testimony from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Caitlin Albert, Brian Albert Jr., Sarah Levinson, Julie Nagel, all indicating never went in the house. John O'Keefe.
All indicating never went in the house. He just mentions that. Not a lot of the other testimony that was pretty inconsistent with the objective data that we had later. Again, that's what kind of makes me just blow my mind about all of the questions he asked all those witnesses. If you just want to know that John O'Keefe didn't come in the house, ask him one question and that's it. But all the other questions, did you see the Lexus? Where did it move? Was it snowing outside? What time did you get there? What time did you leave? Where'd you come from? Where'd you go? Where did you come from, Cotton Eye Joe? That he asked all these witnesses just didn't make any sense. It's crazy to think. It's crazy to think how much time was wasted.
His phone never went in the house from the testimony and the data points that you have from Trooper Green. You know how Mr. O'Keefe was dressed, and you know the defendant knew that. You have the testimony from Kurt Roberts, Jennifer McCabe, Matthew McCabe, Karina Kolakithis, Nicholas Kolakithis, Brian Albert, Cole Albert, Brian Higgins, all indicated in the testimony, and the defendant knew, based on our questions to the firefighters the next morning, that Mr. O'Keefe was not dressed for the weather when he left the waterfall. The weather was a weapon. You have the testimony about the car, the defense car being there in front of the house, moving multiple times. You have that from multiple sources. You have that from Matthew McCabe. You have that from Jennifer McCabe. You have that from Brian Albert Jr. You have that from Julie Nagel. You have that from Ryan. You have the testimony of Ryan Nagel, Ricky D'Antonio, and Heather Maxon. Ms. Maxon indicated she saw a male passenger, female operator as the vehicle was turned. Remember, they're coming towards Fairview at the same time. The defendant, after conducting that reverse, a 3-point turn on Cedar Crest, is then taking a right onto Fairview, while Mr. Nagel, Mr. D'Antonio, and Ms. Maxon.
All right, here we go. Here is his second attempt to prove Karen Reed is behind the wheel. So here we go.
And indicated she saw a male passenger, female operator as the vehicle was turned. Remember, they're coming towards Fairview at the same time. The defendant, after conducting that reverse or three-point turn on Cedar Crest, is then taking a right on Fairview, while Mr. Nagel, Mr. D'Antonio, and Ms. Maxon are taking a left on Fairview. Mr. Nagel indicates that Mr. D'Antonio then flashes lights. During that time, Ms. Maxon can see inside the vehicle. She sees a male passenger. She sees a female operator. They follow the vehicle as they're turning onto the street. Lo and behold, they're going to the same residence. They park. There's nothing in between them and the defendant's vehicle. They indicate that at no time do they see anybody get out of the vehicle. At no time do they see any
Even though, does that really line up with Higgins and where he was supposed to be in his testimony?
damage to the vehicle, or hasn't happened yet. At no time do they see anyone leave the vehicle and go into the house. The vehicle moves up on different successive occasions, as testified to by Mr. Nagel and several others. And then as they're passing that vehicle, Mr. Nagel indicates that he sees a female operator in the vehicle with the dome light on. Interesting, when I asked Mr. Nagel, as far as when Julie Nagel came out to the vehicle, did he roll down the window or did he open the door? He indicated he opened the door. I asked him, what happened when you open the door? What happens when you open the door to a vehicle? Dome light on. So there's a reason I would submit, but the inference that you can make is that no one sees Mr. O'Keefe in the vehicle because that's the moment he steps out of the vehicle. And then they're gone. Ryan Nagel.
So did Ryan Nagel actually say he saw Karen Reed, not just some female, but Karen Reed as the driver at the time? I don't know. I don't know that they did or that he did. I didn't hear it.
D'Antonio and Heather Maxon drive away from that. We have the testimony from Julie Nagel and Sarah Levinson, the peanut butter and jelly sandwich conversation they have with Ms. McCabe, which while they're pulling away from the house where everybody's attention is drawn, Ms. McCabe's turned around facing both of them in the back.
Yeah, nobody's paying attention to the 6'2", 220-pound guy in the lawn. That you wouldn't notice that as you're driving by the house you were in. It's not like it was two houses up.
Ms. Nagel is facing Ms. Levinson on the passenger side, looking out the window towards 34 Fairview Road. Ms. Levinson's looking
Again,
back.
I may be seeming overly critical, but it just, when he puts it all together, it doesn't make sense. In the vote right now, the tally's over 7,000 votes, 3% guilty of second degree, 97% not guilty, and it's almost 50-50 split. Half of you guys think she's just not guilty. Half of you guys think she's actually innocent.
Ms. Nagel away from that area, in which Ms. Nagel indicates that she sees a 5 to 6 foot dark blob on the lawn near the pole in the hydrant, which is just where Mr. O'Keefe is discovered the next morning.
No,
Testimony.
no, Angel. I would have refused to prosecute this even if I had to lose my job.
Oh, and you have text messages in regard to Colin Albert when he gets picked up.
Mr. Lally, 5 minutes.
Yes, Colin Albert, Miss Allison McCabe, Ryan Albert, Cole Albert.
So he gets that warning, and we're going to see him speed race to the end, first off. Definitely go overtime, but not that big of a deal. I just knew people were going to complain about him going overtime, so I wanted to hear it so we could all see exactly how far over he went, which was not actually a crazy amount. Everything aside, AJ is hands down more interesting, if not entertaining, compared to Lally. How do you think that impacts the jury perception of the case? So I will just tell you, this has been a comment I've gotten in some trials that, wow, we really liked your opening statement or your closing argument. You really had us engaged. We just wanted to see what you were going to say next, whatever it may be. And it's always in ones that we've won pretty good verdicts on. And that would tell me that once they start to like the lawyer, once they start to believe the lawyer, once they start to wait to see, they're like, every time you got up, I couldn't wait to see what you were going to ask. It's like, and I've heard that same comment made about my dad. It's like, yeah. And tons of jurors are like, oh, Pete just has the best personality when he picks a jury and he's, telling his jokes and whatever. So you from the jump can get a jury to like you. It makes a big difference in the verdict in the case. Misty, Peter, do you believe in her innocence or not guilty? Gut for me is innocent, but going from the evidence alone, I say not guilty. So it's hard for me at this point to say anything but innocent because I believe the accident reconstructionists when they say based on physics and science and math that he could not have been hit by a car to cause those injuries. And if he was not hit by a car, she has to be innocent. So that's pretty much where I am at this point. SN, Peter, did the prosecution ever explain why the Sallyport video was inverted, or did they just gloss over the fact? They kind of were just like, oh, it's no big deal. We don't know why it came out like that. Technology does funny things. Kelly D, how could Lally bring into his closing about the missing time that was not brought into evidence? The AM they think Karen drove over, didn't think about bad road conditions. Yeah, they're just like spouting stuff off as if it was proven when in reality, it really wasn't. This is a free ad. This is a paid ad by Yobi about how great it is to be a member of the Lawyer You Know channel. Welcome to all the new members.
Caitlin Albert, Brian Jr., all indicating that it was picked up around that time, 12:10 a.m. You have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them goodnight before he goes to bed. You have that testimony in regard to Chris Albert, as far as how John O'Keefe and the defendant come to be at the waterfall in the first place, as far as John O'Keefe and his nephew coming in early in the day, getting a couple slices of pizza, what are you doing later on, contained within those texts. You have testimony from Lieutenant O'Hara, Lieutenant Tully, Sergeant Mechanic about those items being recovered. And in particular, the items being recovered on January 29th by that search. What did Lieutenant O'Hara say? The items were found close to the curb. The items were at ground level, 3 feet of snow that they had to sift through in order to find those particular things. The detail or the delay in the recovery of evidence. The photos in the video, most of which you have in evidence, is earlier in the storm. This is before the 18 inches of snow falls down, before there's drifts and 3 feet of snow in places. They found the evidence where it had been at that same ground level, in the grass, under the snow, at 34 Fairview Road. We heard all of the medical testimony, which I was
By the way, his cadence has changed a little. I know I'm listening to it sped up, but he is flying and just saying stuff. He's just saying stuff that was testified to. It's not really making sense. It's not connecting dots. It's not telling a story the way that he wants to. While I wasn't sure if Jackson was rushed at the end, if he was, it did look like he kind of flipped to his last page, but he kept it cool, calm, and collected. Lally tried to still hit every single thing he had left to say. Mandy said, did anyone else notice that Lally left out Brian Higgins' name when he cited the list of people who said John did not enter the house? I didn't notice that, but I'd actually give him credit because we know Higgins said somebody that was tall with dark hair entered the house.
consistent from firefighter Formati to Dr. Rice. Heard testimony regarding the defendant's blood alcohol concentration from Dr. Fowler and Nick Roberts, 93 milligrams per deciliter, 0.07 to 0.08% at 908.
I mean, he's flying. I'll even slow this down to normal speed so you can just hear how he's flying.
In the morning. You heard it. Mr. Roberts' testimony in regard to the retrograde extrapolation, 0.13 to 0.29, extrapolating back to the time of the operation. The defendant admits to drinking vodka. It's on the receipts from C.F. McCarthy's and from the waterfall. And you have the witness testimony in the surveillance video in regard. The forensic testimony that you have.
I mean, these are some big points, and he's just like, boom, 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 1 point after the next. I guess he's not speaking that fast, but he's just jumping from 1 point to the next so quickly. I can't listen to him this slow. Sorry. We're going to go 1.25. We're going to hit the middle.
In regard to the medical testimony, you have the sort of pattern abrasions, clear plastic that's recovered by Lieutenant O'Hara and Lieutenant Tully on January 29th. The clear plastic that has the dimples on it. No one, not Trooper Paul, not anyone at any point in time ever said Mr. O'Keefe's arm was out like this at the time that he struck, and then he did a pirouette and then flew 30 feet in the air. 12 inches.
Did you hear that? I'm going to back it up. Listen to what he says.
No one, not Trooper Paul, not anyone at any point in time ever said
No one, not Trooper Paul, not anyone at any point in time said this. That's what he said.
that has the dimples on it. No one, not Trooper Paul, not anyone at any point in time ever said Mr. O'Keefe's arm was out like this at the time that he struck, and then he did a pirouette and then flew 30 feet in the air. 12 inches of.
Nobody said that he had his arm out and he was hit on the arm and flew 30 feet and did a pirouette. Now, I will give him that nobody said the word pirouette. But listen to how he's going to change now. This is yet another version of the events. And I go back to that jury instruction I already played. If there are two versions of the events that are equally possible, the Commonwealth did not meet their burden in proving beyond a reasonable doubt. He is about to give us a version of events of how John O'Keefe's body was that I'll admit is plausible and may make more common sense than Trooper Paul's explanation, but his argument is not evidence. Trooper Paul's reconstruction is the evidence, and it makes no sense, and it was disproven by all the defense experts. But this is something we said before, and now he's going to use it. I'm not saying he copied us. I'm sure it's out there online about what would make more sense about the pattern of John O'Keefe's arm injuries, and that's what he's going to try to slide in here in the 9th hour. 11th hour? The 11th hour. The 9th inning, the 11th hour.
Equations that the doctors were, the biomechanical people were talking about yesterday. 12 inches and then 6 inches to the tail end. It's easily solved by this. And the dimples on his arm are, I would submit, are consistent with the dimples on the tail light cover piece, are right around this area of the elbow. You have
a brand new version of what happened to John O'Keefe on day 31, folks. You have 6 inches on the tail light, 12 inches of harm on John O'Keefe's body. And we said, if you bent it, that would make a lot more sense. Guess who didn't say that? Trooper Paul. Guess who could have said that? Trooper Paul. Somebody said I clearly heard the word pirouette. Maybe it did. Maybe it did. I know there was an objection. I thought they agreed that he didn't say pirouette. He said spun or something like that. Regardless, he definitely explained a pirouette or turning around. The stupid shortcuts in a mouse on an Apple mouse are so annoying. I just scrolled down and it booted me out because it made me go back. So sorry. This made a lot more sense than what Trooper Paul actually said. Somebody said Lally broke Peter. I agree. I feel broken now. I feel completely broken. I was kicked out. So this made a lot more sense. And if your expert would have said that, maybe we could have thought about it and discussed it. In my opinion, this jury cannot consider that. They cannot consider that. That is not in evidence. Nobody said his body was that way. Horrible. Horrible, in my opinion.
Testimony in regard to forensics, as far as Mr. Porto, Mr. Bradford. John O'Keefe's DNA is on that taillight house, on the house. His DNA is there to the exclusion as well of Sergeant Buchanan and Trooper Proctor. Mr. O'Keefe's DNA is on the exterior of the broken drinking glass. Mr. O'Keefe's DNA, and only Mr. O'Keefe's DNA, is on his clothing and his fingernails, consistent with Dr. Scortibello's testimony that there is no evidence of a fight or an altercation. There's no one else's DNA under his fingernails. There's no one else's DNA on his clothing.
So he's saying there's no evidence of a fight because there's no DNA under his fingernails.
You have testimony from Ms. Hartman, Trooper Paul, as regard to the damage that they observed, the dents, scratches, 7/8 of an inch hair. You have testimony from Ms. Chart in regard to the mitochondrial DNA profile from that hair being.
Like, you don't have to say every single person's name here, especially in the end when you're trying to squeeze it in. But when you do that, it's just more words. It's less argument. It's less dot connecting. That's a problem. That's a major, major problem. In your opinion, did the prosecution prove its case? No. If not, then do you believe she's not guilty? Yes, I believe she's not guilty at this point. I'd feel pretty confident and hold my head up high like I did the right thing if I was on this jury voting not guilty. Beloved, is an hour of jury instructions that also includes a reference to testimony such as Aruba incident the norm? So yeah, she used examples, I think, when she talked about hearsay or the defendant's words, things like that. An hour is not overly long. Jillian Gruber, were the searches on JM's phone done on Wi-Fi or cell data? I'm not positive. Jesse, if not guilty, will Bev order her car returned and any other possessions of hers they have? Yes. Usually, I should say. I don't know if there's something else going on in this case. Maybe the FBI is testing it. Netwoman, if she hit John, I know they never actually saw the car. It was a joke. If she hit John at high speed, wouldn't there be body damage to the car? You'd think so, but there'd definitely be more damage to John's body. That's where my issue is. Like, and again, bringing my experience of what I've seen in car accidents with broken bones, bruising, pedestrian. Like, I have a case recently of a guy that got hit by a car and his lower back into his butt region is destroyed black and blue. It didn't break any bones and he didn't pass away, but it is purple. Like, it is crazy what it looks like a month later still. And it was not 24 miles an hour. Jumping ahead, will you follow the Sarah Birchmore homicide case that happened in Stroughton, one town over, 3 policemen involved, disgusting men, started when she was 13. So I don't know anything about that case. The way I pick the cases is people ask me. So you guys let me know in the comments, follow on Twitter, on Instagram, and let me know what cases you want me to follow. And that's how we pick every case we follow on this channel. We have 30,000 people combined in this chat, which is our biggest ever. So hit the like button if you guys have not already, and please subscribe. If all you guys subscribe, because about 40% usually are not subscribed, we'll hit 400,000 subscribers. So please subscribe. The whole trial is such a slap in the face, a face of John O'Keefe's family only protecting and serving themselves. Thank you for your reviews on this trial. We are almost at 2 hours. I was hoping to be done before 2 hours on this video. We're getting close. Peter, I heard Lally another day say that there was a taillight chips in John O'Keefe's sweatshirt. Did I miss that? I don't remember that getting testified to, but he was definitely asking questions like, well, what if there were, did you know there were small pieces found in his sweatshirt, not on his body? It was confusing. And I don't think he mentioned it in closing. I could have missed it. Who do you think is going to play Jackson in the movie? I guess what's his name is too old. Kurt Russell's too old. Maybe we go somebody like Bradley Cooper. AJ told a story that could be understood even if you didn't catch the whole trial. Lally tried to, but still did not make it coherent for me. And that's important. Put the pieces together so I can see the puzzle you want to build. Lally's closing is not evidence, so this timeline will not go with them in deliberations. Correct? That's correct. It's just to help them understand. All right, let's listen to his end here.
Consistent with the DNA profile of Mr. O'Keefe. You have the testimony from Ms. Valier and Ms. Hanley in regard to the microscopic pieces, 1/16 of an inch by 1/16.
You have 1 minute, Mr. Lally. Wrap it up.
Yes.
And I think he's actually already late at this point. But she gives him now a 1 minute warning, which she didn't have to do for Mr. Jackson, I don't think.
All consistent with pieces of taillight that are found within his clothing. Ms. Gilman, if I could. 6:05. This is what this vehicle looks like backing up at that speed for.
So he's got 1 minute left. And what does he decide is so important? He wanted to show Trooper Paul backing up as his part of his reconstruction or recreation.
On that distance. There's another years and years ago.
Tell me in the chat, what did that do? Was that effective? To me, it just went over my head. I don't even know why he did that. It doesn't prove anything to me. Can anybody in the chat tell me what was probably, and try to put your other hat on if you don't agree with the Commonwealth's case, and tell me what was good about showing that at the very end of your closing. While Jackson's talking about Proctor's disgusting text at the end, this is what he saved to the end.
Started practicing in Norfolk County, Braintree, what is now Quincy. Eventually became a far smarter man than myself. Eventually became president of the United States. His name was John Adams. John Adams once wrote, "Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence." What the constellation of the facts and the evidence ineluctably demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. Oakley, causing those catastrophic head injuries, leaving him incapacitated and freezing to death.
Mr. Lally, I have to stop you.
So he's gone so over, but hold on. Before she interrupts, I want to listen to that again. This is their case, and this is what he says. Even though he has no expert testimony, no explanation as to where the head hit, where the arm hit, how the body flew, landed, rolled, whatever, no explanation. He's just going to summarize at the end, saying one line, and just, again, like Jackson said, hoping the jury looks the other way and just says, okay, because the cops and the Commonwealth say it, she must be guilty.
Demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. Oakley, causing those catastrophic head injuries, leaving him incapacitated and freezing to death.
Mr. Lally, I have to stop you. You've gone over. Okay.
I literally have one sentence.
1 sentence I'll give you.
From that facts and that evidence, I would submit ineluctably demonstrates their guilt on each of the indictments before you, and I would ask that you find it. Thank you.
All right. Thank you.
That's it. That was the closing argument for the Commonwealth and for Karen Reed's team here at the end. McCabe's not coming out is too sus. I think the dog attacked John O'Keefe, knocked him downstairs. They put him outside. I'm going to hit the last few comments and questions here before we sign off, but we are about done here. If you're going to leave, please hit the like button and subscribe. Hit the reminder bell, okay? Because whenever the verdict gets announced, I'm going to try to go live. If I can't go live, I will still do a reaction to it. Again, the poll, 12,000 votes. Is Karen Reed guilty of second degree? 96% say not guilty. 41% of those, so about almost 50% of the 96% say innocent. Very interesting. Can they object during closing? Yes. If so, why did they let Lally lie and make up stuff as he went on and on? I think they probably thought it wasn't too effective and they didn't want to be rude to object. You can only object for a certain couple of reasons, and making arguments is usually allowed even if you don't agree with them, obviously. Frankie, as a Euro tourist, if an event happened in the U.S., do we call our travel insurance or a lawyer in the U.S.? A lawyer in the U.S. Just start with a lawyer and they can point you in the right direction if something happens. Michelle, even if John's, because anything you say to your travel agent could be used against you, a lawyer is protected. Even if John's arm was bent, how was there no blood on the taillight piece? His arm was cut up by them if he hit them, and broken bones, bruising, all that would still happen. I just do think it's a more plausible explanation. Misty, even if the expert had said that, it does not explain the absence of blood. I agree. Trust me, it doesn't prove the case. It just would have been good. I feel like Cuba Gooding Jr. should play Jackson. I don't know how old Jackson is, right? I don't know how old he is. Steve Carell for Paul Jackson character. I'm very confused by this. Do you mean Trooper Paul? I could get behind it for Trooper Paul. We need some bald actors like Vin Diesel and The Rock. Who can they play? We need some bald actors. John Krasinski to play Alan Jackson is my vote. He's a Boston boy. That's cool. Lots of Boston guys we could get. Ben Affleck and Matt Damon and all the boys together to do this video. I mean, this movie's happening. You know it's happening. Make sure you guys have your gifted memberships turned on to accept them. Net Woman dropping a 50 bagger here for potentially our last video on this case. Well, we know we're going to have one more, maybe two if we get a verdict watch in tomorrow before the verdict comes down. We'll see. But thank you so much, Net Woman, for always gifting memberships, bringing more people into the crew. That's so awesome. I think in his mind, he's getting the jury to think about the last thing the victim would have seen. Okay. So that's the only thing I could have thought is how scary it would be to see this big 7,000-pound truck coming at you at 24 miles an hour. I think he missed the boat on that because I don't think it's actually that scary. If you're standing on the lawn, you wouldn't expect to get hit by something. And if he got hit in the back, right, which they're saying, did he even see it coming towards him? John Adams said that while defending the British soldiers in an unpopular position because it was what was right. Right. Almost some could say the opposite of what Lally's doing. Sawyer, that's a big yikes to Lally's close. Oh, I said I was going to rate them. So I would say Jackson's was a 9.2 and Lally's was, I got to say a 3.9. That sounds horrible, but leaving out the actual incident time of your timeline to me is unforgivable. It's legitimately unforgivable. And saying your accident reconstructionist did not say the accident happened exactly the way he did, those major facts would lose all credibility with the jury. And it's not just like nitpicking. It's not just, trying to be mean or anything like that. If a jury wrote down their notes from his opening where he said 12:45, you lose credibility there. If they were listening to Trooper Paul and then they hear you say that, you lose credibility there. You only have so much credibility as a guy the jury doesn't know before it's all gone. T2, Lally, in conclusion, John Adams once said Karen Reed was guilty. Thank you. That is almost what it sounded like. It'll make one hell of a Lifetime movie. Oh, I think there's bigger eyes than that. I would expect Netflix at least. That was weak for a closing statement. You guys throw out your grades. Throw out your grades for the closing statement. I want to see what you thought. Give Lally a number grade and Jackson a number grade 1 to 10. Christy, is anyone else already worried about what trial we will be obsessed with next? I'm going to miss Mr. Jackson. Peter, we need to figure it out. Yeah, going from good lawyering to bad lawyering is tough sometimes. I could see John Hamm as Alan Jackson. I could see that. Miriam, I can't understand how from all people a prosecutor can give a proven false statement to make his point. To me, that itself is a crime. Usually doesn't work for a jury that's paying attention. Brian G. J.O. exits the SUV, purposely breaks taillight in anger. BH sees and exits house, fight and knockout. BH leaves and BA lets Chloe out. And the dog paws incapacitated J.O. BA and BH calls BA back, plow at 3:30, thwarts moving. So yeah, what's interesting about this theory is a lot of it could have happened and Higgins just left. And then all the Alberts and all the cops could actually believe the rest of the story, right? Theoretically. And it just could have been Brian Higgins. I don't know. I honestly, I just don't know. I don't know. Paul Revere went through Canton. The British are coming. Welcome, Dorothy. RS said the Walsh murder case, Proctor, Guarino, Google searches, same judge. The defense already made a motion regarding Proctor's behavior. Oh, boy. Yeah, I know that case. I know the Google searches are horrible in that case, but how will the Commonwealth's evidence in this case change that? Trina said, Peter, super behind, but wanted to say I went into this thinking frame job, 100% think Lally didn't prove anything. I did realize I usually go into cases biased against the defense. Not anymore. Thank you for all you do, Peter. That's good. I mean, that's really important for our society and our country. People don't want to hear it, and sometimes they don't like it. That is how it's supposed to be. Make them prove it. Because think about if it was you, and you just sit back. You should not have to do anything. They should be able to prove it if they're going to put you in prison, potentially for the rest of your life. Surprised Lally went over time. Incompetent. Not at all. Jackson 9, Lally 3. I'm going to scroll through the comments at the end. The defense said their experts were offered to the prosecution. They didn't use them. Yeah, that's brutal. All right, folks, that's all we got. Thank you, Azam, for the super sticker on our way out. Please hit the like button and subscribe if you haven't already. Until next time, the Jesus piece, Robert said, and Donna said, sorry, I meant Steve Carell for the officer, or from The Office for Alan Jackson. That would be interesting. That'd be an interesting role for him. All right, that's all I got. I'm out of here, folks. I'll see you guys tomorrow. Unless there's a verdict tonight, I'll come back tonight. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.